paper medium is inherently limiting, usually a page of limited length and breadth. The ideas written on a piece of paper are not as easily transferred as bits over a computer network. For this and other reasons, the use of paper has been declining for decades. Australian news outlets recently reported on the boost to Australia Post revenues from the 2017 same-sex marriage postal survey, but noted that this won't be enough to arrest continued decline in letter volumes, which peaked in 2008. This concerns lawyers because paper is what we're used to. Many lawyers have seen the advantages in their practices becoming more electronic, but have often only moved the paper paradigm into their computer systems. This can leave lawyers wondering why they bothered, especially if what they thought would be an efficiency gain actually makes for less productivity. Endless banter in email threads vis-a-vis one letter sent at the end of a day for a matter is a prime example. In this video, we're going to look at the practical uses of the electronic transactions legislation and the rise of the digital world, both of which spell the end of paper. To demonstrate this, we'll look at some of what my own company is doing in the electronic transactions space, the electronic transactions legislation itself, and a significant part of this video addresses the recent case law around electronic wills and the emergence of new systems that have the potential to even digitize succession. My name is Harry Lehman, and I trained and practiced as a lawyer before using the skills I had learned in the law to found the online real estate services platform Vendorable. Vendorable is used by state and federal government agencies, lawyers and insolvency professionals to assist them and their clients in selling and leasing real estate. Much of this video draws on my thinking at the time of starting the business in 2014 about how the internet, software and computers could be used to contribute to a more efficient and transparent real estate ecosystem. Through executing on the vision through to now, and with some learning along the way, Vendorable provides a working example of the shift from paper to digital, and most importantly, why it is preferable. What is the paper paradigm? With respect to computer user interfaces, this describes a text editor looking like a piece of paper with black letters on a white background, files sorted within folders, and a desktop on which folders and/or files might be represented. We're used to this. Another way to look at it is from a private contract or social contract viewpoint. Rules are written down. Think about a contract such as a sale of business written on pages of paper or legislation or even the Constitution. People perform under the rules. Courts and regulators enforce the rules and people's performance under them. This seems very normal. But what if the rules were self-enforcing? Here is an example of a written rule of the legislation from the Estate Agents Act 1980, Victoria. 47A. Seller must be given estimated selling price. Before obtaining a person's signature to an engagement or appointment to sell residential property on behalf of the person, an estate agent or an agent's representative employed by the agent must ensure that the engagement or appointment contains an estimate of the selling price of the residential property that is expressed as a single amount or a price range where the difference between the upper and lower limits of the range does not exceed 10% of the amount of the lower limit of the range and is set out in a form approved by the director. Penalty 200 penalty units. Nothing in this section requires the estimate of a selling price and the seller's reserve price to be the same amount. So, Victoria, an agent giving an appraisal on a residential property may only provide a price range where the difference between the smallest and largest values is 10% of the smallest value. $500,000 to $550,000 is good. $500,000 to $600,000 is not good. To help enforce this rule, the regulator obliges the agent to fill in the figures on what would typically be a paper form. Later on, the regulator could audit the agent and find instances where they have not obeyed the rule. There's a price to pay for not obeying the rule if you are caught. 200 penalty units. The policy reason for the rule is sound. Consumers of real estate services should be entitled to an accurate appraisal because they come from a position with less information about the real estate market. An agent with more information may overquote the property seller, that is, provide an upper price estimate that is well beyond what the market will pay for the property in order to secure the listing. The 10% rule in section 47A is designed to check this. But who is actually obeying it, and how would you know? Should every quote to sell a property by a real estate agent in Victoria be audited for compliance with this rule? Is the right conferred by this rule so important as to justify the expense of enforcing the rule to 100% compliance? These questions become irrelevant if the rule is self-enforcing. When a rule is self-enforcing, it does not rely on an outside actor to enforce its compliance. You can't escape compliance. But how do you create such a rule? Firstly, you have to forget about the paper paradigm. We now have the ability to write rules not just on paper, but into computer programs. And once a rule is alive on a computer network, it becomes very difficult to break. Have you tried typing a search query into Google and then telling Google to return results from Bing? You can't do it. Here is how we made the Victorian 10% rule in section 47A self-enforcing on vendorable. The agent finds a job in Melbourne, Victoria that they want to work on. They can see all of the information that the property seller has provided. They decide to bid for the job. On vendorable, a bid is an offer to enter into an agency agreement. They put in their price estimate and some other details and hit submit. What's happened? A rule which is a few lines of computer code has prevented the agent from bidding because their estimate is non-compliant. If you want to participate on vendorable as an agent in Victoria, this rule can't be broken. In the paper world, however, I could easily break it. We still have written rules on vendorable. Each agency agreement that is formed is governed by a set of default rules, similar to owners' corporation rules in strata or units plan legislation, or a mortgage memorandum registered with the Land Titles Office. But because we have moved away from the paper paradigm, we're able to allow for the engagement of a real estate service completely electronically. The common law has been able to recognise contracts formed electronically just like any other contract through the normal principles. However, in order to provide additional clarity, around the turn of the millennium, common law legislatures began to enact electronic transactions legislation. The interaction of this legislation with the Statute of Frauds and, something which is often skipped over, the exemptions in the regulations to this legislation, are of vital importance in knowing when and how electronic interactions, including signatures, will be enforced by the courts. A fraught example in the Australian context is the contract for the sale of land. In August 2015, the Australian Financial Review reported on the law firm Gadens using electronic contracts and signatures on iPads for the sale of off-the-plan apartments at a site called Infinity by Crown Group.
We've created is a life of infinite possibilities.
Colin Biggers and Paisley is also mentioned for using electronic contracts to formalise purchases by auction at the Greenfield site, The Hermitage by Sekisui House.
Our dream started in this street. Our dream started with this home. Our dream is called the Hermitage. Live the dream.
The article states, Common Biggers and Paisleys electronic contract is formed using DocuSign technology, which ensures that the contract is secure and cannot be changed without detection. Anyone globally can sign the contract instantly on any device. Both sites are in New South Wales. If we take a look at the Electronic Transactions Act 2000 New South Wales, we come to Section 6A, Exemptions. The regulations may provide that all or specified provisions of this Act do not apply to transactions, requirements, permissions, electronic communications or other matters specified or of classes specified in the regulations for the purposes of this section, or in circumstances specified or of classes specified in the regulations for the purposes of this section. The regulations may provide that all or specified provisions of this Act do not apply to specified laws of this jurisdiction. If we now scan our eyes over the Electronic Transactions Regulation 2017 New South Wales, we can see at Regulations 5 and 6, paragraph F, that an electronic transaction is not possible in New South Wales where there is any requirement under a law of this jurisdiction for a document to be verified, authenticated, attested, or witnessed under the signature of a person other than the author of the document. Hold on, doesn't a contract for the sale of land require a witness signature? Well, as it is not a deed, it doesn't. In February 2018, the Law Society of New South Wales responded to the question contained in the State Government discussion paper, Removing Barriers to Electronic Land Contracts. Should there be a witnessing requirement for electronically signed contracts? As follows. No, it should not be required. We note that when the contract for the sale of land and purchase of land is executed on paper, where the vendor or purchaser is a natural person, it is customary for their signature to be witnessed. However, this is not a requirement but a matter of good practice in the event that the execution of the contract is disputed. The same considerations are relevant in the electronic environment. Parties should be able to have a witness electronically sign a contract. We suggest that guidance should be provided in relation to the manner in which a witness should sign a document electronically, given the Electronic Transactions Regulation 2017 does not provide for digital signature by witnesses. We note that witnessing is an electronic environment, whether of a deed or an agreement underhand, is an area with complexities which will need to be addressed. We will discuss e-signing a witness's signatures a little later, but for now let's take a look at the Electronic Communications Act 2000 South Australia, and specifically again Section 6A, Exemptions. The regulations may provide that all or specified provisions of this Act do not apply to transactions, requirements, permissions, etc. As we can see, this section is fairly harmonious with the New South Wales one, although the name of the Act is slightly different and mimics that of the United Kingdom. If we now turn to South Australia's old Electronic Transactions Regulation 2002, which you can see it stayed like this until mid-2016, at Regulation 4.1a, the contract for the sale of land would not fall under the auspices of the Electronic Transactions legislation. This is now changed as of mid-2016, and the current Electronic Transactions Regulations 2017 South Australia specifically make exemption for the exemption to laws requiring witnesses in relation to land transactions. That is to say, you can now have land contracts in South Australia that are electronic and fall under the Electronic Transactions legislation. If the common law is able to recognise electronic contracts, and Given the undesirable result that persisted in South Australia, you might be left wondering why legislation was introduced in the first place. This is a story of legislation begetting more legislation, but also marks the beginning of the end for paper. Let's take a look at the Electronic Transactions Queensland Act 2001 and its Section 11, Requirement to give information in writing. If under a state law, a person is required to give information in writing, the requirement is taken to have been met if the person gives the information by an electronic communication in the circumstances stated in subsection 2. The circumstances are that at the time the information was given, it was reasonable to expect the information would be readily accessible so as to be usable for subsequent reference, and the person to whom the information is required to be given consents to the information being given by an electronic communication. Other jurisdictions have a harmonious section, and in the case of New Zealand, as of September last year, her Electronic Transactions Act 2002 was repealed and moved into the new Contract and Commercial Law Act 2017. Many statutes require information to be in the written form. Continuing to use Queensland as the example jurisdiction, we can see that Section 59 of the Property Law Act 1974 reads, "Contracts for sale, etc. of land to be in writing. No action may be brought upon any contract for the sale or other disposition of land or any interest in land unless the contract upon which such action is brought or some memorandum or note of the contract is in writing and signed by the party to be charged or by some person by the party lawfully authorised." Section 10.2a of the Succession Act 1981, Queensland, provides that a will must be in writing. Section 322.2 of the Legal Profession Act 2007, Queensland, says the costs agreement must be written or evidenced in writing. Is an electronic communication writing? Physically, an electronic communication undergoes various transformations from input at one location to output at another, versus a piece of paper with some handwriting on it, or a printed contract, both of which are bound in space until they are copied. An electronic communication is transcribed, copied and interpreted and what have you many times over in a fashion peculiar to whatever hardware and protocol you are using. Email or TCP/IP, for example. So, looking at the meaning of writing as a physical concept, what we read now on our computer and smartphone screens, we would consider to be writing and come within that meaning. But the physical medium has dramatically changed from the norm of previous millennia. The electronic transactions legislation clarifies that this relatively new medium of information consumption can in fact be writing. This leads on to signatures. We've already noted that a contract doesn't require a witness to be enforceable, but as a matter of good practice in the event that the execution of the contract is disputed. Likewise, a signature is not required to form a contract, but is advisable in order to prove that a party to the agreement approved of the contents of the agreement and intended to be bound by the agreement. As with the requirement for writing, legislation will often require a signature as well. Section 59 of the Property Law Act Queensland requires a contract for the sale of land to be signed by the party to be charged. Section 10.2b of the Succession Act 1981 Queensland provides that a will must be signed. Section 322.3 of the Legal Profession Act 2007 Queensland says the costs agreement may consist of a written offer that is accepted in writing or by other conduct. So to accept a costs agreement, a signature is not required, but acceptance through some form of conduct is necessary. This is the approach taken by the electronic transactions legislation with slightly more specificity. Section 14 of the Electronic Transactions Queensland Act 2001 reads as follows. 14. Requirement for signature. If under a state law a person's signature is required, the requirement is taken to have been met for an electronic communication if a method is used to identify the person and to indicate the person's intention in relation to the information communicated, and the method used was either as reliable as appropriate for the purposes for which the electronic communication was generated or communicated, having regard to all the circumstances, including any relevant agreement, or proven in fact to have fulfilled the functions described in paragraph A by itself or together with further evidence, and the person to whom the signature is required to be given consents to the requirement being met using the method mentioned in paragraph A. The reference in subsection 1 to a law that requires a signature includes a reference to a law that provides consequences for the absence of a signature. In a journal article from 2003 titled "The Statute of Frauds in the Digital Age, Maintaining the Integrity of Signatures," the authors provide the following observation discussing the effectiveness of electronic signatures in the absence of legislative intervention. In all cases, if the law were to require a signature to take the form of a mark on a document, such that it could not easily be removed or reversed, no electronic signature could satisfy the requirement. This is due to the fact that an electronic document is not a physical object, and any method for signing in an electronic environment will not take the form of a permanent affixation to the document. Even a digital signature is merely an extra set of bits attached to the document or logically associated with it, and as such it may be possible to remove the signature. Further difficulties with some form of electronic signatures is that while they may make a mark on the document, this mark does not necessarily identify the party, indicate the party's approval, or become permanently affixed to the document. This observation also demonstrates the influence of the paper paradigm. While the authors grappled with the issue of how physical signatures could be mimicked in the world of bits, they missed the opportunity to discuss how alternative systems could provide the same or better evidence of a party's identity and approval of the contents of an agreement, and thus provide the same or better integrity for the contract between the parties, ensuring the reliability and admissibility of the parties' agreement in a court. The authors say, the challenge is whether an electronic version of a signature will be able to fulfill the same functions. It is actually quite easy to forge a signature and engage in fraudulent transactions in the paper world. I could, for example, get the statutory declaration form of, say, the Commonwealth of Australia jurisdiction, sign as declarant John Smith, and make up or impersonate the identity of a pharmacist or lawyer as the witness, and provide the statutory declaration to whomever. What usually stops or disincentivizes the fraudulent behaviour is the presence, power and control in the physical world of the person who is being impersonated. In July 2014, the Australian Broadcasting Corporation reported on a house in Canberra's north side having been sold fraudulently without face-to-face contact and completed using emailed or posted documents. The owner of the property lived in South Africa and only discovered the fraud when rent payments had stopped being received from the property manager. About a year later, the same news outlet reported on changes being made to the Australian Capital Territory Land Registry. The new system will move away from a largely paper-based and form-based process of registration and conveyancing to a digital conveyancing process. said the Director of Registration and Fair Trading within Access Canberra, John Quiggin. The ACT government wants to offset some of the costs of shifting the massive number of records online by offering a new title watch service. Any time that there is a transaction undertaken or a search of that particular title, it will send the title holder an email to tell them what has happened. And where the property owner is not living in the residence or is overseas, that will alert them, and they can then ask their agent or the person who is looking after the property some questions. Here is an example of an alternative system to paper and signatures, a database containing proof of ownership combined with computer programming which notifies you instantaneously when somebody is interacting with your records. In the paper paradigm, the courts enforce the rules. This is why the Statute of Frauds from 1677 and its successor requirements found in the legislation of common law jurisdictions around the world is such genius. Any time a dispute about a guarantee or contract concerning real estate comes before a court, if there is no written agreement and there are no signatures, the court can quickly deal with the matter. There is no agreement to enforce. Where legislation provides that writing and signatures are required, the court doesn't need to spend resources finding the terms of the contract between the parties, where an agreement is said to have been in place. On the other side of the coin, where the agreement is distilled in writing and signatures are present, the court can presume an agreement has been struck, and that the writing comprises the agreement. The rule in the Statute of Frauds created a shortcut to justice. However, because it is actually quite easy to forge a signature and fake an identity, the introduction of witnessing became widely practiced, and in some cases mandated as part of legislation. Section 10, subsection 3 to 4 of the Succession Act 1981 Queensland provides that the signature of the testator of a will must be made by the testator in the presence of 2 or more witnesses present at the same time, and that at least 2 of the witnesses must attest and sign the will in the presence of the testator. You need the second witness here because once the will comes into operation, the testator is dead. The second witness verifies the testimony of the first, that the testator did actually sign the will, and vice versa. Section 45 of the Property Law Act 1974 Queensland requires the signature and attestation of a witness for a deed to be duly executed by an individual. Witnessing is a further protection against fraud. If a party denies having signed an agreement in an attempt to cancel a transaction, the witness can be brought before the court to provide confirmatory or contrary evidence. This becomes particularly important in the context of mortgage fraud and the Torrens land titling system, where a mortgagee can lose its indefeasible interest where it can be shown that the mortgagee knew, and this includes a situation where suspicions were aroused but further inquiries are not made for fear of learning the truth, that a witnessed mortgage, appearing to be from the proprietor of the land to the lender, was actually fraudulent. Cases around this are Assets Co Limited near Raheny in 1905, part of which I've paraphrased, Gridgick and ANZ Banking Group, which is a New South Wales case from 1994, and Australian Guarantee Corporation Limited and Jager 1984, which is a Victorian case. But what happens when the witness is in on the fraud as well? The Toronto Star recently reported on a situation where, according to the mortgagee's statement of claim, schemesters pretended to own luxury houses and solicited second mortgages. According to the statement of claim, the homeowners used fake identification and posed as self-employed Iranian business people who claimed to have trouble borrowing money from the bank. The mortgagee lenders were provided with counterfeit mortgage and bogus title insurance documents that made it seem like the transaction was insured against fraud. The lawyer acting for the mortgagee hid the fact that some properties already had multiple mortgages and failed to register some of the new ones, according to the statement of claim. What stops fraudulent behaviour isn't the system of paper, signatures and witnesses, it is other people. And in order to prevent and disincentivise fraud, these people must be in control of the things the fraudsters wish to claim as their own. But what if the system didn't rely on other people, and instead the system was self-enforcing? Section 7A of the Electronic Transactions Queensland Act 2001 provides that the Act does not apply to certain things in Schedule 1. By paragraph 6 to Schedule 1, where there is a requirement or permission for a document to be attested, authenticated, verified, or witnessed by a person other than the author of the document, then the Electronic Transactions Queensland Act 2001 will not apply. Wills and deeds, because of their witnessing requirements, are paper-bound in Queensland. The same exemption appears in New South Wales Regulations 5F and 6F of the Electronic Transaction Regulation 2017, in South Australia's Electronic Transactions Regulations 2017 Regulations 51A and 61AI, and in Western Australia's Electronic Transactions Regulation 2012 at Regulations 31B and 41C. The Northern Territory exempts wills and powers of attorney specifically at Regulations 2 to 3 of the Electronic Transactions Northern Territory Regulations. So does Tasmania, with the inclusion of enduring guardianships at Regulations 4 to 5 of the Electronic Transactions Regulations 2011. Victoria's Electronic Transactions Victoria Regulations 2010 just exempts wills at Regulation 6. The Australian Capital Territory doesn't have any exempting regulations. Perhaps it is permissible to make an electronic will in this jurisdiction under the auspices of the electronic transactions legislation. But how could you witness an electronic signature? Some lawyers will argue that due to the very nature of an electronic signature, provisions in legislation requiring witnessing could never be satisfied. This argument arises from the belief that it is impossible to witness an electronic signature. The legislature in New Zealand disagrees. Sections 226 to 227 of the Contract and Commercial Law Act 2017 New Zealand offer the following framework. 226. Legal requirement for signature. A legal requirement for a signature other than a witness's signature is met by means of an electronic signature if the electronic signature adequately identifies the signatory and adequately indicates the signatory's approval of the information to which the signature relates, and is as reliable as is appropriate given the purpose for which and the circumstances in which the signature is required. However, a legal requirement for a signature that relates to information legally required to be given to a person is met by means of an electronic signature only if that person consents to receiving the electronic signature. So this is pretty similar to Australian jurisdictions. Section 227, legal requirement that signature or seal be witnessed, is the missing piece. A legal requirement for a signature or a seal to be witnessed is met by means of a witness's electronic signature if, in the case of the witnessing of a signature, the signature to be witnessed is an electronic signature that complies with Section 226. And, in the case of the witnessing of a signature or a seal, the electronic signature of the witness adequately identifies the witness and adequately indicates that the signature or seal has been witnessed, and is as reliable as is appropriate given the purpose for which and the circumstances in which the witness's signature is required. However, a legal requirement for a signature or seal to be witnessed, if that signature or seal relates to information legally required to be given to a person, is met by means of a witness's electronic signature only if that person consents to receiving the witness's electronic signature. An electronic signature is defined in Section 209 as in relation to information in electronic form means a method used to identify a person and to indicate that person's approval of that information. I suggest that in the Australian context, where the jurisdiction does not exempt it, witnessing an electronic signature in the same fashion as it is described in New Zealand's Section 227 would bring the transaction under the electronic transactions legislation. This would mean that in the Australian Capital Territory, you may be able to make a valid will on the electronic medium without the need for an application to the Supreme Court under Section 11A of the Wills Act 1968 ACT to dispense with the formal requirements for making a will. A problem of interpretation, however, arises. Section 9(1)(b) of the Wills Act 1968 requires the will to be signed at the foot or the end by the testator. How might this formality be satisfied in the electronic environment? Recent case law suggests that there is a growing trend for people to leave informal wills in electronic text documents. In the Victorian case of Re White, Montgomery and Taylor 2018 from the Victorian Supreme Court, the deceased typed an informal will in a computer document prior to taking his own life. The court found that the deceased appreciated the effect of the informal will with references to my estate and how assets are to be distributed that indicate that the document was to have a testamentary effect. In addition, the document file name is George White Final Will and Testament. The court also found that, in contemplation of suicide, the deceased sought to draft his testamentary dispositions as best he could in the form of the informal will, and left directions as to where it could be found. It is incomprehensible that he did not intend it to be his will on the basis that he was aware that it was not formally executed. The surrounding facts in Re Michael deceased 2016 from the Supreme Court of South Australia 164 are grisly, but the manner in which the deceased prepared, purported to sign and purported to have witness his informal computer will is typical of contemporary usage and reliance of new technologies in the place of paper. Reading from the case. The deceased was married to Kerry Lynn Michael, Kerry. The deceased and Kerry were on holiday in Tasmania in February 2015. On 11 February 2015, the deceased killed Kerry. Following the incident, which resulted in Kerry's death, the deceased returned to a caravan at the Devonport Caravan Park, where he and Kerry were staying. He typed the document on his laptop computer. After typing the document, the deceased accessed a digital copy of his signature, which he inserted into the document. Some years earlier, the deceased signed a piece of paper which he then scanned and saved as an image file on his computer. This allowed him to place his digital signature into any document he produced on his laptop by opening the image file and copying and pasting the signature into the document. The document prepared by the deceased in the caravan on 11 February 2015 provides: Last Will and Testament, Robin Michael, 59 Sheoak Road, Bel Air, South Australia 5052. This is the last will and testament of Robert Michael at 59 Sheoak Road, Bel Air, South Australia 5052, dated 11th February 2015. I assign Peter McCullough, my accountant, Brett Michael, my son, Ben Michael, my son, and Nathan Scott Carl, my stepson, as executors of my estate. In the event that I die and my wife succeeds me, then my wish is that she receives 40% of the value of 59 Sheoak Road, Bel Air, consistent with the title, and that remaining assets except Gulwa and split 40-30-30 between my wife and my sons Brett and Ben. In the event that my wife does not succeed me, I wish for Gulwa to be taken by Brett and Ben, as is consistent with the legal structure administered by Peter McCullough, and that the remaining assets combined between my wife and myself be distributed between my natural sons, Brett and Ben, and my stepson Nathan Scott Carl. If Kerry's will is contrary to this, I ask that the executors seek to arrange a distribution as close to this as is possible from the assets remaining after an appropriate distribution as sought in my wife's will. This is my final wish. Signed. Signature appearing Robin Michael, witness. Peter McCullough, 11th February 2015. The document sought to be propounded as an informal will is the printout of the document from the laptop computer containing the digital signature of the deceased. Following the preparation of the document, the deceased sent an email to his accountant, Peter McCullough, forwarding the document and asking Mr. McCullough to witness the document. The deceased copied the email to his sons, Brett and Ben, and his stepson, Nathan Kyle. He committed suicide in Wisdom Prison. If Robin Michael had been living in the 20th century when the holiday in Tasmania took place, perhaps he would have penned the document in his notebook, signed it, torn out the page and posted it to his accountant. Would this have been any more capable of admission to probate? Or to put it another way, would the pen-to-paper document have been less likely to have been fraudulent? I would argue that the computer document is an equivalent, if not superior, source of evidence. There were likely to have been various layers of security Mr. Michael needed to access with a password known only to him. Perhaps a password for his operating system account, and a password for his email account. This verifies the authorship of the document. Further, the email timestamps and timestamps of the electronic text file verify the date of the document. Mr. Michael's computer system is in effect witness to the authenticity of the will. By contrast, a handwritten note showing up in the mail at the accountant's office may have been written by anyone. Circumstances are of course important, but differ from case to case. In isolation, an emailed electronic text file will created on the computer owned by the testator with an email account owned by the testator, seems to me to be more readily verifiable than a paper note. One also does not have to place reliance on the subjective evidence of a handwriting expert. But this is beside the main point. The electronic communications have become the new norm. In re Michael Deceased, the court confirmed that a will, typed on and stored in a computer, is a document for the purposes of provisions in the legislation to dispense with the formalities of making a will. As for the facsimile signature, the court noted that the absence of a signature does not prevent an informal will from being admitted to probate. Other cases had held that a name typed at the foot of a computer document was the equivalent of a signature, and that the signature does not have to be in a particular form. The judge said, "The facsimile signature found on the computer file document and its printout closely resembles the signature of the deceased. I find that it was affixed to the computer document by the deceased as his signature, and that he did so with the intention of giving effect to the document as his will." The judgment does not touch on the purported witnessing via email communication. I would suggest that this is insufficient, and as with any other witness, their actual presence at the time of whatever it is that is occurring is required. But should witnessing the electronic signing of a document via live video stream, or perhaps some other kind of live interfaces between signatory and witness, be acceptable? Or, going a step further, should it not be acceptable to say that the computer system itself is a sufficient witness? In the law of evidence, it is not hearsay to provide evidence of what one saw on live video surveillance. But in any event, the video surveillance itself is admissible evidence, and a better source of evidence than the viewer witness's account of it. A non-human's recording and storage of information in video format is also often preferable to eyewitness testimony. We've all become aware from psychological studies of how the brain creates false memories, and there is data from jury trials to show that we are biased towards eyewitness testimony. In the case of formal wills, I doubt whether most witnesses even remember signing as a witness after a few years, although they should be able to recognise their own signature. The two recent video will cases of In the Estate of Wilden Deceased 2015 from South Australia and Re-Estate of Wai Fun Chan Deceased 2015 from New South Wales demonstrate the problems with this kind of will. In both cases, a DVD recording was found to be a document for the purposes of the provisions in the legislation to dispense with the formalities of making a will, and they were both admitted to probate. And in both cases, the costs of applying for probate were ordered to be paid out of estates valued at almost $200,000 and about $930,000 respectively. In the latter case, Justice Lindsay of the New South Wales Supreme Court said, "Although, as a matter of jurisdiction, a testamentary statement in the form of a video will satisfies the requirements of Section 8, which are the dispensing provisions, the nature of the informality attending an oral statement of testamentary intentions might, in practice, present an impediment to the court being satisfied that the requirements of the section have been met," as Cassie and Coombs 2007 New South Wales Supreme Court 481 at 14-15 illustrates. The transaction costs of satisfying the court that those requirements have been met may be an unnecessary burden on the willmaker's deceased estate, as the present case demonstrates, and the informality of expression that commonly characterises an oral statement may be productive of uncertainty as to the terms or proper construction of a video will, with a consequential heightened risk of litigation following the death of the willmaker. On that account, a casual approach to recording testamentary intentions in a video will is not recommended. In both the computer will cases and the DVD will cases, the document is stored digitally. A DVD will records a person talking and comes with an element of permanence similar to writing on paper. The video captures a physical moment in time, and the writing on paper is a physical object. Of key concern in the computer will cases, where the writing is recorded in an electronic text file, is the ability for the document contained within the computer to be modified. A computer expert is required to give expert evidence as to when the document was created and edited and accessed. For lawyers, this mutability discounts the electronic medium as an appropriate means for will-making vis-à-vis the permanence or immutability of ink on paper. In Re Curry 2015 from the New South Wales Supreme Court, the expert witness provided evidence that the computer document was accessed on various occasions, and as a result, the form field for a date appearing in the document was always auto-updated to the current date. An argument was made that this showed an intention of the deceased that the document was not to operate as his will. The expert witness also provided evidence that the substantive parts of the document were unchanged. There was also evidence of a conversation that the deceased had had with the main beneficiary's mother, where he indicated that he had an encrypted will stored in his computer. These two factors, combined with the language of the document, swayed the court to find that the computer document was intended by the deceased to operate as his will, despite the date field automatically updating. What all of these cases demonstrate is the new world of bits, the electronic world, bumping up against the old world of paper and the paper paradigm. Rules specific to the paper medium have developed to ensure that, as much as possible, fraud is prevented. In the realm of deceased estates, these rules uphold paper, signatures, and witnesses as the best system to distribute assets after death in accordance with the deceased's wishes. But despite the best advice of judges concerning these rules, people have adopted the electronic medium as the new norm. A new system based entirely in the digital world is emerging, and there are two competing ideologies which will determine its future. The contest is one that is older than Magna Carta and familiar to lawyers, historians, political scientists, and economists. Centralized versus decentralized control. One of the aspects of the paper paradigm is that it is decentralized. Rights may be created or modified anywhere with the stroke of a pen. Transactions often occur face-to-face, such as handing over checks, guarantees, or other stores of value in exchange for the transfer of ownership in something or some other right. This can also happen anywhere, and transacting is not mediated by any central authority. The converse is soon to be true in New South Wales for electronic property transactions, where PEXA has been mandated to act as central authority for the exchange of money and title that occurs at completion of a contract to sell and buy land. From the Office of the Registrar General. From 1 July 2018, lawyers and conveyancers will be required to use e-conveyancing for standalone caveats and transfers, mortgages and discharges. This centralised system relies on the individuals using it to place their trust in the central authority and in the individuals who oversee the central authority. But is this the best outcome? No doubt the centralisation of land title records through the torrent system has improved the state of land rights. Forcing a centrally controlled means of transacting those records on the market, however, might prove to be a mistake. The alternative decentralized model has two important aspects to it: immutable record keeping and self-enforcing rules by way of computer code. In this system, the immutable records hold property rights, and the self-enforcing rules both describe and perform transactions with those records. No one entity is the repository of all records, since users hold the records in a system of peer-to-peer distributed databases. Cryptography ensures that additions to the database do not introduce changes to prior records. In this way, the advantage of the immutability of paper in the physical world is kept. We say in the law that a contract is only as good as the parties to it. In such a system, it is possible to create a contract that is only as good as the contract itself. The distributed and open nature of such a system allows anyone to write a contract which self-performs in accordance with how it is written, without necessarily relying on the parties to perform post-agreement. Instead of trust being placed in the parties to perform under the rules, the fact that the rules have been written ensures performance. Of course, this isn't going to capture situations where physical performance is required, but certainly in the case of ethereal concepts such as money and ownership, rights and title, the exchange of these things can be triggered to occur without further performance. The point is that such a system, being open and distributed, allows users freedom and provides an objective source of truth. In a system which is centralized, users must petition the central authority to make changes, and users must trust the integrity of the authority who controls the source of information.